God assumed from the beginning that the wise of the world would view Christians as fools, and he has not been disappointed. If I have brought any message today, it is this: have the courage to have your wisdom regarded as stupidity. Be fools for Christ. And have the courage to suffer the contempt of the sophisticated world. There is no basis in text, tradition, or even in contemporary practice, if that were enough, for finding in the Constitution a right to demand judicial consideration of newly discovered evidence of innocence brought forward after conviction. My concern is that in making life easier for ourselves we not appear to make it harder for the lower federal courts, imposing upon them the burden of regularly analyzing newly discovered evidence of innocence claims in capital cases, in which event such federal claims, it can confidently be predicted, will become routine and even repetitive. As long as judges tinker with the Constitution to do what the people want, instead of what the document actually commands, politicians who pick and confirm new federal judges will naturally want only those who agree with them politically. Bear in mind that brains and learning, like muscle and physical skill, are articles of commerce. They are bought and sold. You can hire them by the year or by the hour. The only thing in the world not for sale is character. That's the argument of flexibility, and it goes something like this: the Constitution is over 200 years old and societies change. It has to change with society, like a living organism, or it will become brittle and break. But you would have to be an idiot to believe that. The Constitution is not a living organism, it is a legal document. It says something and doesn't say other things. Persuade your fellow citizens it's a good idea and pass a law. That's what democracy is all about. It's not about 9 superannuated judges who have been there too long, imposing these demands on society. It is difficult to maintain the illusion that we are interpreting a constitution, rather than inventing one. You're looking at me as though I'm weird. My God! Are you so out of touch with most of America, most of which believes in the devil? I mean, Jesus Christ believed in the devil. It's in the Gospels. You travel in circles that are so removed from mainstream America that you are appalled that anybody would believe in the devil. Most of mankind has believed in the devil, for all of history. Many more intelligent people than you or me have believed in the devil. A Bill of Rights that means what the majority wants it to mean is worthless. If you're going to be a good and faithful judge, you have to resign yourself to the fact that you're not always going to like the conclusions you reach. If you like them all the time, you're probably doing something wrong. What is a moderate interpretation of the text? Halfway between what it really means and what you'd like it to mean? Devout Christians are destined to be regarded as fools in modern society. We are fools for Christ's sake. We must pray for courage to endure the scorn of the sophisticated world. Day by day, case by case, the Supreme Court is busy designing a constitution for a country I do not recognize. If we cannot have moral feelings against homosexuality, can we have it against murder? Can we have it against other things? Certainly the Constitution does not require discrimination on the basis of sex. The only issue is whether it prohibits it. It doesn't. The court's decision reflects the philosophy that judges should endure whatever interpretive distortions it takes in order to correct a supposed flaw in the statutory machinery. That philosophy ignores the American people's decision to give Congress all legislative powers enumerated in the Constitution. They made Congress, not this court, responsible for both making laws and mending them. Words have meaning, and their meaning doesn't change. Individuals who have been wronged by unlawful racial discrimination should be made whole, but under our Constitution there can be no such thing as either a creditor or a debtor race. That concept is alien to the Constitution's focus upon the individual. To pursue the concept of racial entitlement, even for the most admirable and benign of purposes, is to reinforce and preserve for future mischief the way of thinking that produced race slavery, race privilege and race hatred. In the eyes of government, we are just one race here. It is American. The attitude of people associating guns with nothing but crime, that is what has to be changed. I grew up at a time when people were not afraid of people with firearms. We do Him, God, honor in our Pledge of Allegiance, in all our public ceremonies. There's nothing wrong with that. It is in the best of American traditions, and don't let anybody tell you otherwise. I think we have to fight that tendency of the secularists to impose it on all of us through the Constitution. More importantly, the court forgets that ours is a government of laws and not of men. That means we are governed by the terms of our laws, not by the unenacted will of our lawmakers. If Congress enacted into law something different from what it intended, then it should amend the statute to conform to its intent. In the meantime, this court has no roving license to disregard clear language simply on the view that Congress must have intended something broader. For in order for capitalism to work, in order for it to produce a good and a stable society, the traditional Christian virtues are essential. There is nothing new in the realization that the Constitution sometimes insulates the criminality of a few in order to protect the privacy of us all. The mere possession of monopoly power, and the concomitant charging of monopoly prices, is not only not unlawful, it is an important element of the free market system. The opportunity to charge monopoly prices, at least for a short period, is what attracts business acumen in the first place. It induces risk-taking that produces innovation and economic growth. Having had the good fortune to serve beside her on both courts, I can attest that her opinions are always thoroughly considered, always carefully crafted and almost always correct, which is to say we sometimes disagree. That much is apparent for all to see. What only her colleagues know is that her suggestions improve the opinions the rest of us write, and that she is a source of collegiality and good judgment in all our work.